I'm Caroline Fredrickson. I'm the president of the American Constitution Society, and I think, I certainly hope that most or all of you know ACS and know what we do and our members. If you're not a member, however, I would urge you to join, and I can actually tell you that you could do it today. Our friends at the table outside can help you figure out how to do that. But for those of you who may not know ACS, we are a nationwide network of lawyers, law professors, law students, policymakers, and judges who believe that the law should be a force to improve the lives of all people. Our mission is to promote the vitality of the Constitution and the fundamental values it holds: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. On this Constitution Day, we are celebrating and honoring two attorneys who represent those very constitutional ideals, and in particular the ideals of due process and the right to counsel, even for the most unpopular. Our Keeping Faith with the Constitution honorees are Debo Adegbile and Gregory Craig. You can find their biographies in your program. I will not go through all the details because we would be here a long time going through all of their many accomplishments. In any case, most of you probably know something about them because they are so well known for their outstanding legal careers, which include public service and private practice. I'd also like to give a thank you to the sponsors of our event, and particularly to Cravath, Swaine, and Moore for hosting us here. And the sponsors you will also find in the brochure. So we are very, very fortunate at ACS. We've had a wonderful group of board members, including a former board member, Steve Sussman, who's here, and we have Christine Varney, who is here at Cravath, who is going to be the moderator for today's discussion. Now, Christine, whose biography I will also not go through, which is also included in your program, is another incredibly outstanding lawyer. She has been widely honored as a litigator. She's held extraordinarily high posts in the federal government in both the Obama and the Clinton administrations, and has won any number of honors, which again I won't go through because we have a limited number of time, but I will mention that Christine has been named as one of the 100 most influential lawyers in America by the National Law Journal. And so we are in good hands to have Christine lead what I think is going to be a very interesting and inspiring discussion. So,
great.
Christine.
Thanks, Carolyn. And if Greg and Debo are ready, why don't you guys come on up and get mic'd. Good afternoon, everybody. Thanks, Caroline. We're so glad you could join us here for what I hope will be a very interesting conversation, and hopefully you'll be inspired by what you hear and get more information about, you know, how to have the kind of meaningful lives that our two honorees have had. As you've heard, we're joined today by Debo. I'm going to really mangle your last name, Adegbile.
Perfect.
Did I get it? Oh, great. Debo, as you may know, was on Monday announced to join WilmerHale as one of their head senior litigators here in New York, where he will continue his tradition, long tradition, of very important litigation advancing civil rights, voting rights, and as well as hopefully get some financial security for your family, yes. Which is, I think, an interesting question when you ask people who've balanced a career in government service and public service, how they meet all of the demands in their lives. And Debo is certainly someone who is doing that and has done that at the NAACP Legal Defense Fund and at the Senate Judiciary Committee. Now, Debo is probably familiar to many of you both as the most recent nominee, and he just sadly informed me he withdrew his nomination to be the Assistant Attorney General for Civil Rights in the Obama administration. And we're going to talk about some of the reasons why there were some in the Senate who felt it appropriate to take a very honorable pro bono representation that Debo handled and turned it into a partisan political football completely inappropriately. Now, I know you'll probably kill me for saying this, but the other reason some people may know him is that for a whole generation of people, he taught people how to say their S's and their X's, as well as many others when he was a recurring actor on Sesame Street. and did a very good job on that.
That was much easier, as it turns out.
My longtime and very dear friend, Greg Craig, was never on Sesame Street, although
I tried.
depends on which character our kids would say either one of us would play. Our children grew up together, and we raised kids together in the same neighborhood. Greg is currently a partner at Skadden, a great firm with also a long tradition of pro bono service. And Greg should be well known to you all as both the former White House counsel to President Obama and very involved in the defense of President Clinton's impeachment. He has had many high-profile representations, some of which we'll talk about today, including representing defendant John Hinckley and representing, for those of you that are old enough to remember, Elian Gonzalez's father, among many, many others. So what we're here to talk about today is pro bono. And, I just was with some of my colleagues, and forgetting my Latin, I said, pro bono means feel good, right? Do good, be good. And they said, yep, that's what it means. And lots of pro bono work really does feel good. Here at Cravath, we've done a lot of representations helping people get political asylum, representing people on death row, helping people who are facing their children being extradited back to a potentially abusive situation. And many of you have been involved in cases like that, including our guest today. But pro bono doesn't always feel good. And pro bono involves taking on representations sometimes that are wildly unpopular. And we're going to talk with our guest today about those, among many things, about those kinds of representations, why they're so important and how you handle them, and what are the lines and where do you draw the lines. So, I think that we might want to kick off with Greg. You've been on a couple of really tough ones. And you've handled them well, and you've been successful in a lot of the tough cases you've been on. How do you deal with the animosity that gets generated when you're defending an unpopular cause, and why do you do it?
I'm trying to go through all the unpopular causes that
You've had a few.
How do you deal with it? You expect it. First of all, I suppose the Hinckley case had 2 or 3 levels of dealing with it. One was the level of agreeing to take on the case initially, and there was a really sort of meaningful meeting with the executive committee of the law firm the day after President Reagan was shot, and the morning after John Hinckley's father had called the law firm and asked if we would represent John. And it was something really sort of out of a television program, because all the arguments that you would have expected to be made against and for were made by litigators who are very good at doing this. And one of the arguments was that morning we had seen in the Washington Post a picture of someone that looked a bit like John Hinckley, a skin-headed kind of guy who was in some Nazi uniform, and so there was this, how can we represent a Nazi who has just shot the President of the United States? And there was a political component to that. Are we encouraging extreme hate-filled groups by doing that? The argument was there was nothing that we could do for him that a public defender couldn't do for him. We couldn't bring much to it other than that. There was a blatant economic argument we'd lose. They went down the number of clients that would leave. And it was all turned around when Ed Williams said, I think this is the sort of case that a law firm like ours should be able to do, and if we can't do it, no one else will be able to do it. And he made the following statement. This is the first level of how you deal with unpopularity. He said, we all have kids, maybe 1 or 2 of them are a little crazy, and if he had 7 kids, one of my kids up in New York did something stupid like this, or irrational, or went bonkers, got arrested, was going to be prosecuted, and I called up Arthur Lyman, and I said, Arthur, would you represent Bennett? And Arthur said, no, I'm sorry, my partners don't approve, and we might lose. I wouldn't have much respect for the profession. Well, it was Ed Williams making the argument that carried the day, so that day I was off interviewing John Hinckley and determining from day one, almost the first day that we were interviewing him, that there was a serious possibility of running an insanity defense. Now, the interesting thing to me, and this is not your experience, we had an enormous amount of attention from the press. It was the biggest trial that was going on when that insanity case went on. And we never talked to the press at all. We didn't. That was our ethic. We didn't explain the lay evidence. We didn't try to narrate the nature of the defense. It just came in. And so I think when the verdict came in, a lot of people were surprised that the jury had been convinced that John was seriously crazy and found not guilty by reason of insanity. And the antipathy that emerged from the verdict dwarfed everything else, and it was led by the Senate. The jurors were summoned to testify in front of the Senate Judiciary Committee. This is one of Orrin Hatch's.
Is that constitutional?
Well, I don't think there was a subpoena. They were invited, and the foreman went up and defended, I think, well, the case, the verdict. Obviously, they changed the law of insanity in the federal courts as a result of that verdict. But in terms of what happened, the closest was dealing with my wife. She says, "I understand John Hinckley deserves a lawyer, but it doesn't have to be you." But after a while, she sort of got into the spirit. But when John started calling over the weekends, and this is John, and she answered the phone, that was a little too much. But I think the system at that time really did protect the lawyers better. And I've not found representing John Hinckley having any adverse impact on my professional career. Maybe people forgot about it. Maybe it's not something that is close to the surface. And maybe it's also because the Reagan family handled it so beautifully. There was no effort to politicize or take advantage of it or inflame people as a result of it. Mm-hmm. They were the White House was very classy throughout the trial. I had much more during the Clinton impeachment, anger generated and telephone calls at 2 a.m. by people who had maybe had a little bit too much to drink, who went down the directory or called directory assistants, and lo and behold got my name and called in, and those were profane, and you didn't pay any attention to them. But in terms of, actually, the Miami Cuban crowd got angry during the Elian Gonzalez.
I would imagine
demonstrated outside of our house, and when I went running in the morning, they would run along with me, and they called.
You ran by my house. I remember it well. Look, Greg's getting chased by all the Cubans.
The morning that Elian was rescued, we call it a rescue from that crazy situation down in Little Havana in Miami. The Spanish language radio station broadcast the home telephone numbers and my office telephone numbers to everybody, and so the phone started ringing. And my daughter found out that I was going to burn in hell, and I got a transcription on my voicemail at the law firm that whenever I got depressed, I would play again because it perked me up. It was Mr. Craig, and I'm not going to use the F word, but that's it. You son of a bitch! So that, how do you feel about that? You expect it? It really doesn't. I was sort of pleased I was getting them angry, actually.
Well, you had the very famous Mumia Abu Jabal, which doesn't have any of the kind of glamour that some might mistake Greg's representations for. That one had to be very tough. What compelled you to do it, and how did you handle it? Sure. And why don't you explain what that is for people that don't know?
So Mumia Abu Jamal was one of the most widely recognized death sentence prisoners in the world, really. Mm-hmm. He was convicted for having killed a police officer in Philadelphia in the 1980s, and it was a very controversial case that raised a lot of rancor on both sides of the case. And the Legal Defense Fund has been involved in capital defense work since the time of Thurgood Marshall, and that proud tradition continues to this day. And the team that was working with Mumia Abu-Jamal litigated a number of legal issues on appeal, and many of the issues went to the sentence as opposed to the conviction, and there were a number of constitutional errors that were claimed in the trial. And LDF had filed a number of friend of the court briefs on a couple of occasions, and as director of litigation, it was my job to review the briefs, make sure they were consistent with the doctrine, and making the most compelling case that we could make in vindication of the principle, whether it be a Batson issue or other issues that were at play in that case. And LDF filed a couple of those briefs, and in my role as lit director, I read them and gave comments along the way, and that was that. Of course, because this case is so politically charged, there had for a long time, and I think I was about 13 or 14, the director of my elementary school is in the audience, Michelle Sola from Manhattan Country School, and I was at that school at the time that this crime happened, and so I didn't, as a young person, know all of the controversy, but I came to know it as an adult. But our focus was on the law and the doctrine and the serious legal issues that are important to be vindicated in capital representations. At some point after it was argued in the federal appellate court, LDF was asked to join the team itself for purposes of defending or prosecuting, as the case may be, the appeal in the United States Supreme Court. The death sentence was thrown out by a federal appellate court for a constitutional error involving the sentence, and ultimately LDF worked on a petition to the Supreme Court suggesting that the lower court was correct and that the jury instructions were unconstitutional, and we were successful in that representation. And so what's interesting about it is that there is a whole a lot of understandable rancor about the case. It was very political. It was in part about the racial tensions in Philadelphia, the conflict with law enforcement and the African American community. Obviously, you have in every capital case, there you begin with a death, and so it's very difficult and harrowing for the family. Mm-hmm. And there's a widow. Officer Faulkner's widow is alive and has been vindicating her husband's name through the years, and so you had this sort of clash of two worldviews. But a lawyer's job is to focus on the legal arguments and to advance the case. And because we did that effectively at the Legal Defense Fund and vindicated the Constitution in the way that lawyers are supposed to, that was the role I played, and something that I don't shrink from.
Can you comment on the irony in the fact that you've, as both a human being and a lawyer, fulfilled an incredibly important role in our civil society of advocating to ensure that justice is carried out, and that was used by some in the Senate to try to block your nomination to a constitutionally appointed position?
Sure. So the way I like to think about the political process, and I had I'm not the only person to have had this experience, but I had the unusual experience of both being a Senate Judiciary Committee staffer and a nominee at the same time. And so there was an added level of joy to this process of going to get lunch and being the guy that people were whispering about as you were at the salad bar. There are some people I know in the audience, so they may correctly introduce a fact correction and suggest that whatever I was doing at lunch, I was not at the salad bar. You may make your own observations, but I did put a couple of green things on my plate to distract. But the point was, it was a very interesting situation, right? To be somebody who was a nominee for this important office, and at the same time was walking among the folks, some of whom were excited about the service to which you had been called, and others who were spending many of their waking moments trying to find out how they could stop you from vindicating that service. And to be sure, it was an interesting process, but for me, I've been so committed to these principles for such a long time, and I'm in part committed to them because I know the history. As I was preparing for today, I went back and I reread the Scottsboro Boys case, and I took a look at Gideon v. Wainwright. These are the seminal opinions about the right to counsel in the United States. And on one level, you have the amendments to the United States Constitution, but the thing that I think we at ACS and all of us in the United States need to focus on is that the Constitution, no matter how majestic the words, is not self-executing. These principles, these rights are only vindicated if people, whether it be brave clients and lawyers and judges in many contexts, step up to the plate and make sure that the promises are realized. And so having been a student of the history and how it evolved, to have the opportunity to engage in it and to make some contribution, however small, in that process, to me was an honor and something that I've been glad to do in a variety of contexts. And when you look at it in that way, I think it temporizes the madness of the political situation, because what you have at bottom and what anchors you is who you are and why you do what you do. And if you're clear on those things, there are going to be lots of things that are beyond your control. But at the end of the day, you walk away knowing that you've indicated a principle, or at least worked hard to do so, and that enables you to sleep well at night.
Should we have a bar rule or a state licensure rule that requires everyone to do pro bono and forbids, as a matter of ethics, criticism of anyone who's on the fact of their pro bono representation? You can criticize their actual representation or their methods or their arguments, but some sort of rule that does both sides. Everyone must fulfill a pro bono obligation, and under the ethics rules, you cannot attack an individual for having undertaken a pro bono representation. What do you think?
So I guess my own view, and I know that some states are experimenting with some of these rules, my own view is that neither of those rules are the best approach. Obviously, speech is another important value.
Ethics rule. Ethics rule.
Right, but you know, I think to be sure what you have hypothesized is an ethics rule, but we come back to the core value that's in play, and it's very important to debate the qualifications and preparedness of government officials to serve or nominees to serve, and I think it's fair to have a broader public conversation about the role of lawyers in society. What's unfortunate is that it doesn't always happen that way. So it's not a conversation. It's a bit of an effort to sort of obfuscate rather than illuminate, and so that's unfortunate. But I don't think the ethics rule is the way to get there. There are lots of people like Greg, myself, yourself, people at firms, in government practice, and at not-for-profits who have a platform to vindicate these principles, to talk about their importance. The ABA should be at the front of this conversation. It should be a policy initiative of the American Bar Association and of all the other bar associations to talk about this underlying value. But an ethics rule, I think, isn't really the best approach, in part because the extent to which you see these things coming out there means that they are real and they exist, that not everybody has signed on to the underlying value of the right to counsel and the role of criminal defendants or others having the opportunity to be represented. And then as for the pro bono rule, this is something that's close to my heart as well, as somebody who worked collaboratively with lots of law firms and lawyers and who began their civil rights representations as an associate at a major New York law firm, and hope to continue some of that work at WilmerHale. But there I would say, look, every lawyer has got to get into the fray and do things that they care about and have that commitment to their lawyers. If this is a checkoff, if this is a box that people need to check to continue to keep their license in place, I worry about the quality of representation that people are going to receive, and I think that for that reason I would prefer a different approach. I support the sentiment, but I think that it may lead to a situation where you don't always get the best representation if essentially you're coercing people to offer this service.
Greg, you're nodding, so I assume you're...
Well, I'm agreeing with Debo. I think you don't enhance the quality of the pro bono bar by requiring everybody to practice in the pro bono community. Is that me? I would say that it would be very, very valuable to have major institutions like Cravath and like Skadden have a culture that promotes pro bono, respects it, praises it, recognizes it, and uses it as a way of evaluating the people that are associated with the law firm. I think that's very important for the profession, that the powerful institutions inside the profession support it. But for those of you who are harboring secret ambitions of one day serving in high government office, I don't think you should take Debo's example as a reason not to take on high-profile, unpopular cases. First of all, his nomination was in the midst of probably the most acrimonious, polarized period in the history, at least in my lifetime, surrounding the issue of judges. So people with no sense of professional standards or professional conduct were gathering any kind of evidence or argumentation. At another time in our history, I would have thought that this would not be a problem. And let me just make the alternative argument that high-profile, unpopular cases are a chance for you to distinguish yourself and stand out because of the way you behave professionally, because of the way you handle unpopular cases, because of the standards that you set for the profession, even though your client may be a serial killer or a police killer or a communist or a president who misbehaved and is unpopular. The way you conduct yourself can enhance your reputation and the bar as well. So I think that rather than running away from cases that are risky or cases that may produce adverse publicity, I think you ought to welcome them and look for opportunities to do exactly what you have done, which is to serve a higher purpose. You know, when I was 2 or 3 years out of law school, I started out at Williams & Connolly, and then I got married to a graduate student at Yale, and she was not happy about the idea of leaving New Haven and going down and living in the life of a wife of a lawyer. So I had to go up into New Haven, and I was a federal public defender for 2 years, one of the best things that ever happened to me. And I had the same sense that you're talking about, Debo. Every time, by the way, that was a period of time when the Fourth Amendment was alive and well, and so we had a really great motions practice in the federal criminal bar. Every time I got up there, I thought, my gosh, this is, you know, a trial of the power of the Constitution, on my ability to persuade the judge that on the evidence that we gathered in the suppression hearing or the cases that we were going to prevail, that there was meaning in the Constitution. It wasn't just an empty vessel that people paid lip service to. It really had an active impact on the state of a case and the future of an individual. And it was exciting, even though these were, you know, people that were bank robbers and dope dealers and arsonists. They were not people that you would run for president of the United States, but what you were doing was an incredibly honorable and important function, I thought, for the whole process.
Well, that's interesting, Greg, because you're doing that as a federal public defender, and it's your job. And you mentioned Darius said to you when you undertook the representation of Hinckley, yeah, I get he's entitled to a lawyer, but it doesn't have to be you. Are there cases you would not take? And where do you draw the line? How do you balance your personal moral beliefs with your commitment and belief in public service?
Well, there are a lot of good reasons not to take a case that have nothing to do with a moral principle. You don't have the time, you don't have the availability, you don't have the interest, you don't think you could do a good job. I think there are very, very few criminal cases that I would decline to take on a moral basis. You know, sometimes I'm teaching trial practice or evidence or federal courts in law schools, and people say, how can you sleep at night representing people that you know are guilty? That's not a problem. It's when you're representing people that are innocent, and the only thing that stands between a huge injustice is your abilities in the court. That's what keeps you awake at night. So I would say, as a criminal matter, I don't think that there's virtually any case that I would decline to take on a moral basis, because I think it's important to keep the system tested and resilient and legitimate, and that happens when there's very, very strong litigation on both sides.
What about you, Debo? Anything? Where does the personal intersect with the public commitment on these kinds of issues?
I guess my own view is that everybody has to find that line for themselves. I'm sure people have different life experiences and commitments that make them think that a particular area would be an area that they don't want to touch. You could easily understand why somebody who had been the victim of a crime would not be comfortable representing some of the types of people that Greg and I have represented, and you have to honor that, and I think it's appropriate. Most of all, it would be difficult for them to discharge their duty in that context. For me, I guess I haven't spent a lot of time thinking about this, but I have spent a lot of time trying to expand access to the vote and the franchise in the United States. So no matter how glamorous the argument, I don't think I would want to find myself on the other side of a case that was trying to narrow access to our democracy. That's a personal line for me, and something that I wouldn't want to do. I'm sure there might be others, but if you're asking what comes to mind, you don't call me if you want to argue that the Voting Rights Act is unconstitutional.
Right.
Call Greg.
That's not a criminal case. Christine, I'm just remembering, now that you've got me thinking about this stuff, I'm just remembering an example where I wouldn't have nothing to do with the case. And it has to do with, I think, a personal association or friendship with the victim. When I was in the 60s, doing civil rights and anti-war stuff and working very closely with a congressman by the name of Allard Lowenstein, became close friends with Lowenstein. He was murdered brutally in his office. A deranged person came in and shot him 5 times. That deranged person was a friend of one of my partners at Williams & Connolly and called the law firm and asked if Williams & Connolly would represent this person who had just murdered my friend. I said, it's fine with me as a matter of principle for Williams & Connolly to represent this guy, but I can't be part of the law firm. I would leave because I just couldn't come every day and work with my partners who were engaged in trying to represent this guy. That principle was then applied to the Hinckley case. And there was a circular around to the law firm, does anybody have an association or a friendship with any of the victims in John Hinckley's? There were 4 people that were shot, including James Brady and a policeman and a Secret Service man. And if there was anybody who felt that he could not or she could not remain in the law firm during the period of time that we were representing the person who shot them, we would revisit the issue.
Interesting.
And so that I think is
We had one at Hogan,
respected.
where I was for many years when I was in and out of government service, where the state of Florida was a client of Hogan, a regular paying commercial client. And they came to Hogan, I don't even recall if they wanted us to do it pro bono or were willing to pay for it. They wanted us to represent the state of Florida in defense of a regulation that they had enacted that prohibited gay people from adopting children. And this would have been it probably was in the mid-90s. And I was in the management of the firm at the time and felt extremely strongly. And the basis of the Florida prohibition at the time was that gays were unfit to be parents. And I said, among many reasons why we are not doing this, we have gay partners. You're going to tell me that this law firm is going to defend a state regulation saying people who are gay are unfit to be parents? That's not a firm I'm going to be a part of, and I can guarantee you there are, more than half the members of this firm are not going to be part of a firm that would take that position. I don't care if it's a Florida state constitutional or a states' rights issue. It really doesn't matter. And by the way, no good happens under the banner of states' rights, in my view. Anytime somebody's coming to you with one of those, you watch out. So, tell us a little bit about who are the influences in your life in public service, and who's sort of, you've talked a lot about your commitment. Where does that come from?
So I guess it comes from 2 separate sources and maybe more. And I think about, I'm a person who has led an interesting life and sort of been at many different stations along the socioeconomic ladder. And so I've had the opportunity to see that folks don't always get a fair shake, and that their voices don't always get heard. And being able to be a lawyer and be a voice for the voiceless and some folks that need somebody to step into the breach and be their voice is something that in part comes from my personal experience. And I was fortunate to go to schools that sort of taught about this history and about how central a value it is to our country. And so I claim that first. I also had some very important mentors. When I was at Paul Weiss, one of the senior lawyers there was the late, great Judge A. Leon Higginbotham.
Yeah.
Judge Higginbotham had been the Chief Judge of the Third Circuit, a great lawyer, judge, a historian of some reputation, and he was about the best mentor of young lawyers that I have had the opportunity to experience. And he would sort of invite you in and ask you your views, and whatever case we were working on early in the case, he would ask how you would close in the trial, which caught a first-year associate a little bit off guard for a couple of reasons. We were sort of focused on the narrow legal issue that we were researching, and Judge Higginbotham would pause and say, you're bringing this case for the ultimate adjudication. How do you synthesize it? And as terrifying as it was a helpful exercise to sort of step out of yourself and sort of think about the big ideas. The good part is that he encouraged you and wanted to hear your voice. The bad part is that after you made your feeble effort, he would do his. And that was always humbling for a couple of reasons, not the least of which was his James Earl Jones-like baritone and of course his extraordinary gifts. But he told me a story when I was a young lawyer, and he told me a story about when he was a very young federal judge. I think he became a federal judge at about 34 or so. And it was at a time that our country was still grappling with a lot of violence in the American South, and the civil rights movement was certainly happening and in process, but the dangers had not been removed. And he was asked, I believe it was on something like Constitution Day, or maybe it was the 4th of July, to go give a talk in Mississippi. And everybody warned the young African-American federal judge not to go give that talk. They said, don't do it. It's just not worth it. You'll be a target. It's not a good idea. And the judge told me that he decided that he had taken an oath to uphold the Constitution, and if he personally was not prepared to go vindicate that oath in any of the states of the Union, then he was not fit to serve. And so he went down there, and the person who was his escort was a man by the name of Vernon Damer. Vernon Damer, for those of you who know your civil rights, is one of the martyrs of the civil rights movement. He was a storekeeper and a middle-class guy in Mississippi who used his store to register voters at a time when it was very hard for African Americans to register in Mississippi. And Vernon Damer was the judge's escort. And when they went from site to site, as the judge went around for this visit, after they would get out of the car, Vernon Damer would take a piece of invisible thread and sort of jury rig it around the car. And the judge, so he was always sort of trailing the judge as the judge walked off. And the judge asked him what he was doing, and he explained that he was doing this because if the thread was disturbed, then he would know that somebody had been at the car. The idea was that they were there at a time when having a bomb set on the car with Judge Higginbotham was a very real danger. And I learned from Judge Higginbotham that later the Ku Klux Klan came to Vernon Damer's house after this visit. And they set upon the house and set the house on fire. And Mr. Damer went to get his rifle to defend the family and return fire so his family could escape. He told them to leave out the back door, and the family left, but he was very badly burned, and he died of his injuries in the hospital. And on his tombstone in Mississippi is something that he said as he lay in his deathbed: if you don't vote, you don't count. And so when I was able to sort of see the great Judge Higginbotham, who was the toast of the town at Paul Weiss, able to litigate any case, every client would want him, to teach the young lawyers the lessons about what had happened in his lifetime and how we had walked on the path so that I could be an associate at Paul Weiss Rifkin, I thought to myself, look, if you have an opportunity to get in the game and make a contribution, there are those who have given a whole lot more for these protections that we have, and I'll take a lap and let the chips fall.
So, Greg, you've had an enormous influence on a wide array of young lawyers in the work that you've done over the years, and you've done such incredible and important work. And one of the tensions I'd love you to talk to people about is, you took lead on trying to close Guantanamo, and that was a tough thing. And many people have commented in contemporary times that Guantanamo is the biggest blight on our Constitution. Yet, as pro bono lawyers, we've all kind of embraced this idea of defending the detainees. And yes, the detainees are certainly entitled to defense. But how do you reconcile the tension between the fact that we have this, what some would say, abhorrent blight on our society in Guantanamo, yet we as lawyers are all called in service in some ways to legitimize it?
Well, I think actually the profession has, by and large, behaved very well in connection with I think they were slow in coming to the realization that these detainees should have lawyers and they should be protected by institutions, the lawyers. But I think by the mid-2000 period, the American College of Trial Lawyers, for example, was paying tribute to a number of lawyers who had taken on detainees and had won some cases. So, and I think by that time, the profession generally was respectful of those lawyers and was supporting those lawyers who were representing detainees. I think it's not the profession so much as it is the political situation and the courts got into it far more than I would have predicted at the beginning. They found a habeas right. They concluded that there were standards that should be used in evaluating whether they continue to be incarcerated. But there is tension there between politics and the law that is not new. It happens all the time in our favorite city in Washington, D.C. It is perhaps most excruciatingly obvious in the presence of the President of the United States, who is a lawyer and one of the best lawyers and legal minds in the country, but also has a political agenda that perhaps has higher priorities than closing Guantanamo. My view was that if you were going to close Guantanamo, you really had to do it in 2009 or 2010 because it was not going to survive. In 2008, all the political leaders in both parties were in favor of supporting Guantanamo. This was a bipartisan issue at the time of President Obama's inauguration in January. So you had to move very quickly and you had to be decisive and you had to stare them down and fight them down. But at that time, there were, in fact, and I'm not going to dispute, that's what the president is there to do, is to make these tough decisions. He had to get the economy right. He had to pass an $800 billion stimulus package. He was focusing on health care reform. And to take on the fight over Guantanamo was a political battle, I think, that they were not willing to do at that point. We're paying a price for that even today. I don't know if people noticed, but the second person who was murdered more recently by ISIS on television, the person who did the murder says, Obama, you promised to close Guantanamo and you didn't. So, and the orange jumpsuits are selected. So Guantanamo is living with us, not just as something that is regrettable and disappointing, but it's also paying a price for it in terms of the way in which parts of the world view us.
How much damage has been done to the Constitution by the operation of Guantanamo?
Well, I mean, I don't think you can quantify it. It's done a good deal of damage, in my view, to the way in which the world has looked at us or looks at us. And I think it's actually done some damage to President Obama's capacity to be a leader in the world. I mean, when he came in, I think one of the reasons he got the Nobel Peace Prize was the executive orders that he signed the second day, which ended, enhanced interrogation techniques, promised to closing down Guantanamo, set up a whole new system of task forces to evaluate detention policy and interrogation policy. And it looked as though there was going to be a sharp change in direction, which didn't turn out to be quite as sharp as we'd perhaps hoped it was, or the world expected it to be. But the fact that Guantanamo is still open, despite his pledge to close it, I think does do damage to President Obama's standing elsewhere in the world. I can talk more about that than about the Constitution. The Supreme Court has done two or three things with it. One of the great arguments, I think, was in front of the D.C. Circuit the other day. So there's been some great moments on the question of whether material assistance could be something that the military tribunals could address. I think the existence of the military tribunals is a real challenge, legally as well as politically, and that is also something that President Obama agreed to. That a compromise was to continue the military tribunals, and by any measure, it seems to me the military tribunals have been a failure. We have tried in the civil courts half a dozen, maybe even 10 people charged with terrorism since 2008, and they've been tried, convicted, sentenced.
Right.
We've not gotten one trial completed in military tribunals in Guantanamo. In my view, they should be scrapped, and we should, if we're going to try these people, we should try them in civil courts, convict them and sentence them, rather than having them sit down in Guantanamo. And I think that's enormous damage to the Constitution, that failure.
And there could be public defenders or pro bono lawyers defending the detainees.
Absolutely.
In
I mean,
US courts.
We've got a public defender representing the person who seems heavily involved with the bombing in the Boston Marathon.
Yeah.
That's exactly the right way to deal with this case.
So what I want you both to talk about for a minute, and then maybe we'll open it up for some questions, is it seems to me there are a multitude of ways one can serve the public good as a lawyer, and one is through taking on unpopular or underrepresented causes as a private lawyer, but taking it on pro bono. The other is through government service, which we've all well done. What do you see as the differences between serving in a pro bono capacity as a private lawyer and serving the public good in the public sector? And one of the things that we've touched on is, when you're serving in the public sector, particularly as a public defender, it's your job. Somebody bombs the abortion clinic and kills 3 women and a doctor, you still got to defend them. That's your job. So can each of you comment a little bit on how you see, as lawyers, us advancing the public good and keeping the Constitution alive and well in both the private pro bono side and the public service side? And
Sure.
Debo, why don't you start?
So you've seized upon one of the important differences. Very often, when you're in the public sector, you have a different mission than you might at a law firm. But the good thing is, because of our ethical duties, when you take on a representation, that difference falls away. Your duty is to vigorously defend the interests of your client, and you sign up for it and you have to do it. There's some practical differences that sometimes matter, which go to resources. I took my early civil rights and pro bono cases at a major New York law firm, and the resources that were available to prosecute those cases, defend those cases, were tremendous, and they can make a difference. Resources in complex litigation make a big difference. The quality of the lawyering matters, but being able to hire that expert to do that investigation, all of those things can really separate whether or not justice is done from a miscarriage of justice. And so that matters a great deal, and it's an important thing that firms bring. I'd say that I saw fabulous lawyering in both contexts, so I wouldn't necessarily say that the quality of the lawyering is different, though there is some expertise that comes in any area of law from doing it over and over again, and there can be important differences there, but that's why the collaboration, the public-private collaborations can really be mutually beneficial, certainly to the client, but also to the lawyers as they grow and they learn from each other. I began, as I've said many times, at a large law firm, and from a pro bono case that I engaged in for a long time with Judge Higginbotham and lawyers at the Legal Defense Fund, I was recruited to the Legal Defense Fund when a vacancy became open. I received a call from the former chair of the EEOC, Jackie Berrien, who was going on to a different position, but we had been co-counsel. And I was able to make that transition from that pro bono experience, and that sort of lighted a different path and continues to.
Right.
There's a category of pro bono cases that we haven't really talked about, which seems to me to be very, very important, and also personally very satisfying. It's not just the high-profile constitutional issues. It is serving a population that is vulnerable and is unable to get the kind of legal representation that promotes justice and promotes fairness in the system. And for example, at Skadden, Washington, D.C., we have tried to focus our pro bono activities and bring some order to it and targeting and energy to it on every issue that involves families in the District of Columbia. So we're working with a children's defense organization, we're working with the schools, we're working with domestic violence situations, and those partners inside Washington, D.C. know that Skadden is going to go out of its way to provide all the resources that we've got in our pro bono project to focus on stuff involving families. Now, when I was a public defender, as you might guess, a lot of the people that come into the criminal system, first offenders primarily, poor, indigent, unable to afford lawyers, also are needy in terms of social services, and that's a point for intervention where you can get them hooked up with various state and federal agencies that can help them through whatever they're trying to navigate, whether it's family issues or educational issues, landlord-tenant issues. So that there's something very, very satisfying about that side of it. It's not high profile. Right. It's not something that people are going to write in newspaper articles about, except in some exceptional purposes or examples. But it's I think, the core of pro bono service of the profession, which is not, it's not going to be in the limelight. It's not going to be something that's going to be in your resume, but it is really important service. I think working for a Secretary of State or a Senator or a President of the United States is a very different undertaking because unless you're doing constituent service work, you don't feel the direct impact on the individual that you do when you're doing pro bono work, and you don't have that sense of, gosh, but for me, that person's life, I really was able to help in some respects. You're working at a level that can influence in a very, very important way large groups of people, but it doesn't have that same quality of impact on individuals.
So I'm going to tell one story of one of the most exciting moments I had in pro bono service, and I'm going to ask you for an exciting moment story. It must have been in 1986 when I was doing pro bono work with David Boies for the Democratic National Committee. We had a suspicion that the Republican Party was running a voter suppression campaign in Louisiana. And we were able to find that there was a consent decree, surprisingly, that the Republican National Committee had entered into in like 1980 or 1982 in New Jersey. So we went to the New Jersey judge and said, we think they are violating the consent decree, and we got discovery. And many of the young people in the room won't know this, but back in those days when you had discovery, you had boxes of documents. There were no computers, there was no cell phones. There were literally boxes of documents. So we had gotten discovery. We were at the Republican National Committee in Washington, myself, David Boies, and another associate. And we were going through the boxes of material, and I was about 7 months pregnant. And I pulled up a folder, just like this, and opened it up, and in it, I saw a note from the Southeast Regional Director of the Republican National Committee to a nominal third party, and attached was all the voter suppression materials, posters that they were putting up saying, if you moved in the last 5 years, you can't vote. If you don't have, back then you didn't have to have ID. If you don't have ID, you can't vote. So I found it, and I knew that I had found the smoking gun. And I started screaming. I was a very young associate, started yelling, and there were 2 guards that the RNC had put in the room. They thought I was going into labor. Immediately, there was all kinds of flurry, and I took that folder and shoved it to David, who immediately put it in his briefcase. And we were able to quickly get the RNC banned from participating in the election for Senate. It was the election that John Breaux won. And I think to this day, John Breaux in part attributes that victory to the fact that we were able to stop this massive voter suppression campaign in Louisiana, and it was one of the most fun moments I've ever had in public service.
David still remembers that case.
He does.
Yes. Yes.
You have a fun
Wow.
story?
So I guess it's hard to pick one in particular. Sometimes when you're litigating these cases that are a civil rights all the marbles case, you are trying to think about the principles and the doctrine, but you're also trying to be in touch with the people whose lives will be affected. And so this isn't so much a story from the courtroom as it is about making that nexus between the people and the cause. And so Elise Boddy, the former litigation director of the Legal Defense Fund, who's a con law professor at Rutgers, is in the room joining us today. And she and I walked into the Supreme Court together to go defend the Voting Rights Act in the Shelby County case. Right. And we were greeted by our clients on the steps of the Supreme Court. And one of them is an older guy who served the country in the military. And as we walked into the courtroom, he had on his United States hat with the flag on it, and he gave us a hug, and he gave me an embrace, and he he jabbed me in the chest and he said, go do it. You're ready, go do it. And I leave it to the rest of you to decide how ready I was or whether I did what needed to be done. But at least on the way in on that day, knowing that you were standing for something. This is a man who had lived through a time in Alabama when, because of his race, he couldn't vote.
Yeah.
And all these years later, he was standing up to try and keep the protections in place. And to make that nexus between the high constitutional principle and the people on the ground who have lived the history is one of those moments that you remember. And the bookend that I will very quickly mention is that we went right from the oral argument to Selma for the march across the Edmund Pettus Bridge. And there, everybody gathers every year for a reenactment of the march. And I saw John Lewis in the middle of the street in the shadow of the Edmund Pettus Bridge. There was a big, I guess, some type of march going on, and people were walking to the podium. And I saw Congressman Lewis, who of course had been beaten on the Edmund Pettus Bridge on Bloody Sunday, and I tapped him on the shoulder, and I wanted to say hello. I knew he had been at the Shelby County argument, and before I could say anything, he turned around and he gave me this bear hug. And we were right there in the street, in the shadow of the Edmund Pettus Bridge, and he said, you did a good job. You did a good job. And again, I leave it to you to decide how good a job was done, but it meant a lot to me to be standing in that place, hearing from that person who was still fighting this fight all these years later, that it's an important fight to carry on. So those are two personal moments that I'll remember.
Greg?
Back in the day when sentencings were real-life sentencings before the guidelines, there were some very powerful and dramatic moments in court that I will never forget, representing individuals that had a lot of problems going on, and that was when courts would listen to a lot of people talk about what the sentence should be rather than looking at a cookbook and determining what a guideline range should be. But I suppose one of the most single satisfying moments was when Juan Miguel Gonzalez recovered his son. That was a real amazing moment. For us, we went in there with the government of the United States on our side, sort of, the law on our side heavily, and all the politics against us. I mean, when we started representing Juan Miguel, first of all, we couldn't persuade him or the government of Cuba to come to the United States initially. So it was hard to speak for him, the father. And secondly, the airwaves were filled with the evils of Castro and communism. And the commentators, I thought, were remarkably ignorant about how these issues ordinarily are handled in the United States. And I can remember some of them, I won't tell you their names, would fasten on, well, we should do whatever is in the boy's best interest. And of course that meant, God, don't send him back to Cuba and grow up in communism. So that was a phrase, I'm in favor of doing whatever in the boy's best interest. That is a standard that is applied sometimes in American domestic courts, but the huge presumption is that it is in his best interest to go with his parents, unless there's evidence to establish that the parents are unfit. And that latter part of it was never identified. So we had, I think the polls said that 85% of the American public, when we started working on this case, supported him remaining in the United States and not being sent back to Cuba. By the time Juan Miguel came in, by the time he'd been interviewed, by the time we'd presented these arguments, it had reversed dramatically, and I think 3 out of 4 Americans were all for putting the family back together again.
Elian must be grown by now.
Yeah, he's 20 years old. He'll be 21 in November.
Any chance he'll be in America at any time?
I doubt it. I think he's had his Disneyland visits.
Karen, can we open it up for questions for just a few minutes? Can we take some questions, Steve?
Last summer I suggested to my younger brother on a hike, he's with the ABA, that the ABA should get behind a bipartisan resolution that no Senate committee considering a nomination for a lawyer for any high position can ever use something the lawyer said or wrote and agreed to put in court on behalf of the client against him. Either on the left or the right. Democrats can't do it, and the Republicans up, Republicans can't do it, and the Democrats up. My brother thought it was a great idea with the ABI. The next week, by the way, he sent me an email that said it's already prohibited by the Code of Professional Responsibility. And he gave me the citation to the code and said it's an ethical violation for a lawyer to criticize another lawyer for that. You know, things, I even recommended the ACS that they do something. They didn't do anything about it. And then when your nomination came up, I happened to be at a meeting in Washington where the civil trial organization of 30 some odd or more lawyer groups that are that meet twice a year. And I don't know, I wasn't on the agenda. I've suggested to this group, apparently I'll be good.
It's a big business in
I
Washington.
suggested to this group that why don't we, as a group, make this resolution, because they're all lawyer groups, they're defense plaintiffs, Republicans, Democrats. And why did it begin right here with the lawyers? Just to tell people it's improper.
Yeah.
And you know, there was a lot of snake. I don't know whether it was right before or after you, but it was at that time.
Mm-hmm.
It was time. Of all the groups present, only one was opposed to such a resolution. And they have a rule that unless it's unanimous, there's no resolution. They have that rule of 60. I can tell you which group the one that was opposed. There was nothing ever came of that. So here's my pro bono case. I, on a pro bono basis, will represent you in a lawsuit, an ethical complaint against the senators who criticize you because they're lawyers. Okay? I go to their bar associations and file a complaint that says you violated the Code of Professional Responsibility by publicly criticizing a lawyer for something he did for a client. How about that? You up for it?
As your lawyer, I would advise you to think about this.
When I agreed to do this panel, I didn't know that there were going to be ways for me to become more popular in Washington. but I now see that hope springs eternal.
I didn't mean to comment. Seriously.
Yes.
I like both your attitude. Why can't we do something like this? Get the American Constitution Society, the Federalist Society, pick some Republicans and Democrats on the Judiciary Committee, find someone at the, I don't know if the White House will join, but find someone. This is something that could be done. It's totally bipartisan. It explains to the public that this is what lawyers are supposed to do. We have an ethical responsibility to vigorously represent our clients, whether they are pro bono clients, as you point out, or paying clients. It doesn't make any difference. Now, if I make a speech, that's a different thing. If I write a law review article, that's a different thing. Of course you can use that against me if I'm up for a judgeship or some other position. But there should be some, and apparently there is law. But we lawyers are not standing up for other lawyers who get criticized for doing what the Code of Professional Responsibility requires them to do. And we ought to begin doing something, and it ought to begin on this Constitution Day in 2014, right here at the ACS luncheon. And if the group here would be behind that, we could take it somewhere, folks.
Greg, do you want to comment?
I think it's a great idea. I'm curious to know whether the chairman of the Judiciary Committee is even aware of that prescription. And whether, first of all, the idea of doing anything bipartisan in the Senate Judiciary Committee is somewhat of a fantasy. So realistically, I'm not sure that there's any way we can do it, and I'm not sure what the arguments would be against it. But we could certainly embarrass people who were unwilling to sign up to this standard that seems to be there in the Professional Code of Ethics by suggesting it. And perhaps the way of pursuing this in a bipartisan way is a challenge because it's so polarized. You can't give it to Chuck Schumer because he would immediately have 5 people against him. I'm not sure that you could do it with Pat Leahy either, or Orrin Hatch. It's tough. You've been working there, so maybe you have a better sense of the reality of it. I fear that it would be looked at as a political ploy rather than as a real serious effort. I support it. I think it's a good idea.
Debo, you want to comment?
So I think the chairman is aware of the ethical rule. The president of the ABA did send a letter to the Senate Judiciary Committee, Mr. Silkenat, at the time that my nomination was winding on, and I think he cited some of the operative provisions. But I guess there is a gap between what the rules are, and this is your point, and what the reality is on the ground. And as a culture of lawyers, as a profession, most of us know what the rules are. But many of the things we've talked about have been at that nexus of law and politics. And law and politics now it plays out in the public square. It also plays out in the electronic media. And I think more broadly in the United States, the values that we hold true and that we swear to uphold as lawyers, there's a little bit of a gap in the general public's embrace of all of those things. You know, it's hard to explain why some people would have representation to some folks that aren't members of the bar. And so there needs to be more attention on this, because if it's not addressed, it could propagate, and we swirl around the drain with people that are prepared to serve and offer service. What the approach is, I leave it to others. But I do think that the issue needs to be elevated in some way, that there can be a constructive debate in the public square.
But one idea would be to get to try to recreate the dream team that did the gay marriage thing, and have a bunch of Republican lawyers and a bunch of Democratic lawyers sign an op-ed or do something very powerful that's visible, that then you could organize around when it comes to confirmation proceedings, or be part of the record. I mean, if you could get those folks, and I think the leading Republican barristers and solicitors in this country would support something like that. That's where I would go to try to organize the bipartisanship rather than the Judiciary Committee in the first instance.
Maybe time for one more question? Yeah, go ahead.
Hi, I'm Mary Lynn Rose at the Prisoners' Rights Project at Legal Aid, and so we are always welcome when other people join us representing unpopular clients. I mean, actually, all of your firms have all done a lot with Legal Aid. And in that connection, but I was just thinking about 2 aspects of the kinds of pro bono you're discussing that I'd be interested in hearing how, from a law firm's institutional perspective, how you either have met those challenges or stumbled in trying to meet them. And the 2 I'm thinking of are particularly representing clients who are severely mentally ill, or your clients who are homeless and you can't call them to say, come to the meeting. Those kinds of things that might require social work staff, and what sort of support you think law firms need to think about, what you've put in place to help your attorneys do those. And secondly, on the high profile cases, the extent to which many of these cases that you, Mr. Craig, are talking about are now being litigated with the modern social media climate, the 24-hour news cycle, the intense partisanship we have. And whether those require new skills, whether they make the cases more or less fun to work on, and how institutionally, again, the pro bono model has evolved or needs to evolve to do that, the sort of modern day zealous representation.
Let me just address the second question first. The 24-hour cable news cycle was alive and well during the impeachment.
Yeah.
We had to anticipate every 6 or 7 hours the next wrinkle, whether allegations of some child that Bill Clinton had fathered in Arkansas. That would be one allegation. And I mean, we had one after another that we had to deal with. So it's not all that new, the difficulty. And I can remember President Clinton saying, I really admire John Kennedy. He was able to put aside 13 days in private to work on a decision having to do with the Cuban Missile Crisis. If he hadn't had those 13 days, he might not have come out the right way. It's a challenge for every president to get time, to say nothing about how you litigate in this context, to get time to make decisions that are wise and well thought out. The precise problem that you talked about in the first part of your question is something that Skadden in Washington, D.C. has been wrestling with, because we obviously don't have capacity to provide, except on a case-by-case level, if we have a client that does need a social worker on a regular basis, we may have the resources to do it, whereas legal aid does not. But there's about 3 or 4 levels of ways to deal with it. One, Skadden led a huge fundraising campaign just to finance legal aid,
Right.
and to give them, we raised, I think, $1 million this year, for legal aid in Washington, D.C. Secondly, those partnership groups like yours, prisoner rights groups, they're the ones that frequently bring these kinds of cases to our attention, and those partnerships then become mutually beneficial because the organization has access to some, for example, on the streets, you guys probably are able to work. The public defender's offices in Washington, D.C. have investigators on the streets all the time to locate witnesses, where we can't do that. And so that it's a marriage of resources and commitment that, in the best instances, really is something to be proud of. It works.
Do you want to comment?
Just briefly, I think that legal aid and other organizations, they need to light the path and explain what the cases take. I mentioned earlier that folks in public service may have some specific issue expertise, and you know things about what it takes to litigate a case. The lawyers at the Legal Defense Fund know what it takes to deal with a death penalty case on appeal and what's involved in doing the investigation and all of those things. And as I understand it, I'm new back to the big law world, having taken a 14 or so year hiatus. But look, you have to figure out what the number is, what's involved in it, and then make the pitch that it's an important case to do. And once you get the commitment from the firm, I have known firms to be very generous in their support of pro bono cases. The real difficult thing becomes, how do you scale these things, right? I mean, that's a tougher question. In an individual case, you sort of need to make the match. But how do you scale it if you're identifying a particular problem of homelessness? We at LDF, when I was there, we represented a homeless person in a voting case under the motor voter law. The person wasn't being offered an opportunity to register to vote when he had contacts with agencies that are supposed to offer him a right to vote, and because of his homeless status, it was a problem. There were a lot of challenges in the case locating the client, conveying information about hearings, depositions, and the like. That expertise that you and others have is very important, and if there is some way to lay out this is how you do this with a particular type of case and population, a short white paper, then maybe that can be levered up.
I think you see increasingly at big law understanding these issues, and I know at all of our firms and here at Cravath we heavily support legal aid, but we're starting to expand our support to those organizations that legal aid needs us to support. You can't fully represent and defend a victim of domestic violence without a lot of ancillary services. So I think we're looking at our pro bono service increasingly as an integral piece of an entire package that has to be put together in order to actually solve problems. So we're part of the problem solving, an integral part, but we're by no means the total solution. And going back, I think one of the things that everybody can think about doing in those years where you don't have time to take a pro bono case, maybe you can contribute financially to some of the organizations that plug in and work around the gaps. I know we're all trying to get our law firms to think more broadly about what pro bono means, because you can't just have the lawyer in court getting the restraining order. If the victim has nowhere else to go, most likely she is going to get beat up again. So, you know, there's just a huge array of services that have to go with that, and I think we all know that. Well, congratulations to our 2 awardees. Carolyn, do you want to finish up?
You know, I think we can all agree that the conversation was even better than we could have anticipated, inspiring, I think, for all of us to go out and do good for the world, as we should under our Constitution and our ethical requirements. So on behalf of ACS, I would like to present each of you with our Keeping Faith with the Constitution Award. And it's heavy. I'm sorry, Greg. I know you're back to DC, but
Greg, I'll keep yours
really,
for you.
Actually, Debo, I want yours.
everything you've done, and it was a wonderful
Thank you.
discussion. Thank you, Christine.
Thank
Can
you.
we all give them a round of applause? And thank you all for coming. Join ACS if you're not a member yet, and we look
Good to
forward to
see you,
seeing
man.
you again at our next event. Thank you so much.
Come visit us.
Yeah, I sure will. Yeah, I sure will.
Thank you. That was really